What's up everyone, welcome back to our page, and this video I will be discussing a round robin resolution. Now the Companies Act specifically addresses the issue of resolutions. It also allows the Memorandum of Incorporation to have a substantial impact on resolutions. The resolutions of shareholders of companies may be passed in one of three ways. Firstly, at a meeting under Section 61 of the Companies Act, number 71 of 2008, or secondly, by way of a round robin written resolution under Section 60 of the Companies Act 2008. And thirdly, if there is a sole shareholder, it may pass the resolution summarily and without procedural formalities under Section 57 of the round robins are now statutorily regulated by Section 60 of the Act. Now, Section 60 of the Act provides as follows. Subsection 1, a resolution that could be voted on at any shareholders meeting may instead be submitted for consideration to the shareholders entitled to exercise voting rights in relation to the resolution and voted on in writing by shareholders entitled to exercise voting rights in relation to the resolution within 20 business days after the resolution was submitted to them. Subsection 2, a resolution contemplated in subsection 1 will have to be adopted if it is supported by persons entitled to exercise sufficient voting rights for it to have been adopted as an ordinary or special resolution, as the case may be, at a properly constituted shareholders meeting, and if adopted has the same effect as if it had been approved by a voting at a meeting. That's the end of the section, guys. Now, although this is an alternative method for directors and shareholders or shareholders meeting, it cannot replace an annual general meeting that is mandatory as prescribed by the Act or the company's Memorandum of Incorporation. This is in terms of Section 60, subsection 5 of the Companies Act of 2008. Now, the requirement for a round robin resolution is the resolution must have been submitted for consideration to the shareholders beforehand, and the matter is voted on in writing within 20 business days after the resolution was submitted to them, and then within 10 business days after adopting the resolution in terms of a round robin. The company must deliver a statement describing the results of the vote, consent process, or election to every shareholder who was entitled to vote on or consent to the resolution. Now, a round robin resolution is conducted by correspondence, usually by way of an email. Formal notice needs to be given and needs to adequately inform shareholders of the purpose of the resolution. Now, voting is to take place within 20 business days of the resolution being sent, and the shareholders are to be informed of the results of the resolution within 10 business days of the resolution being finalized. The curious aspect of round-robin resolutions is that the Act is not clear as to the number of voting rights needed to carry a resolution. In terms of other meetings, there must always be a quorum present. The Act speaks of a quorum as 25% of the voting rights. With round-robin resolutions, there is no such certainty, and a number of contrasting views as to what will suffice. One view, possibly the majority view, is that a 25% voting response is needed. Another is that a majority of those who vote decide, in which event, in an extreme case, if only 1% of the voting rights vote, they would make the decision. Other possibilities are decision by a majority of the voting rights of all issued shares, or a requirement of 100% unanimity. In companies with only a few shareholders, this will probably be an issue, but as the shareholder number grows, the potential to manipulate decisions via round-robin resolutions exists. It is unclear what stance our courts will adopt in the event of any dispute over the validity of a round-robin resolution, so take professional advice if you are in doubt. In any event, in view of this lack of clarity, one solution would be to remove all doubts by specifying in the Memorandum of Incorporation the number of voting rights necessary to pass a round-robin resolution. For a number of matters and transactions, a special resolution of shareholders is required. Now, a special resolution entails a 75% majority vote. However, this position can be altered in a company's Memorandum of Incorporation, subject to there being at least a 10% margin between ordinary resolutions and special resolutions. This is in terms of Section 65 of the Companies Act. It should be noted that for listed companies, the threshold of 75% for special resolutions cannot be lowered, as this is not permitted by the Johannesburg Stock Exchange listing requirements. Now, the special resolutions that are required under the Companies Act of 2008 are set out in Section 65, Subsection 11, and may be summarized as I will now, which is a special resolution is required to amend the company's Memorandum of Incorporation, ratify a consolidated revision of a company's Memorandum of Incorporation, ratify actions by the company or directors in excess of the authority as contemplated in Section 20, Subsection 2. Approve an issue of shares or grant of rights in the circumstances contemplated in Section 41, Subsection 1. Approve an issue of shares or securities as contemplated in Section 41, Subsection 3, or authorize the board to grant financial assistance in the circumstances contemplated in Section 44 or Section 45. Approve a decision of the board for reacquisition of shares in the circumstances contemplated in Section 48, Subsection 8. Authorize the basis for compensation to directors, approve the voluntary winding up of the company, approve an application to transfer the registration of the company to a foreign jurisdiction, or approve any proposed fundamental transactions and revoke a special resolution which triggered appraisal rights under Section 164 of the Act. That was a mouthful, guys. Now, the parties dealing with a company under the Act of 1973, the Companies Act of 1973, were required to obtain a CIPRO search and have the auditors countersign the resolutions of shareholders and directors to confirm their identities and authority to act. Now, under the 2008 Companies Act, a director who is appointed or elected or entitled to act ex officio is required timelessly to deliver to the company a consent to act as director. Now, the company is obliged to keep a record, not a register as in the 1973 Act, of directors and to advise the CIPC via Form COR 39 of changes to directors within 10 business days of the change. Now, the 2008 Companies Act does not say whether a director's authority to act ceases if the COR 39 form is not delivered to the CIPC timelessly. It is submitted that the director's authority will remain valid. Failure to file the forms that I've listed or discussed is no longer a criminal offense. At worst, it appears that an administrative fine may be payable. Companies may no longer entrust these functions to their auditors because it is no longer obligatory for some companies to have auditors. Now, the obligation on a company to be audited will depend on the company's public interest score. And that is it for today's video, guys. I hope that was informative, and if you guys want to know more about round robin tables then or resolutions, then please go to our website www.lawyers.easyfind.co.za. Also follow us on all our social media platforms for more information, such as Facebook or Instagram, and also follow us or click the subscribe button on our YouTube channel. Click the bell button for post notifications for more videos like this, and stay tuned